Let me get my little microphone. Oh, this is just, I think. You guys have your, okay. I've had somebody test them out. We're good to go. So welcome to the Senior Truth Series. And a lot of you have not been here before, so we would love for you to follow us on Facebook and to check out the website. And I'm continuing to work on the website. I'm going to get these videos up there. So a couple people have asked me about past videos, and I promise you I will get them up there. Maybe I'm technologically challenged, I'm not sure. But it's going to happen. So if this is your first time to the Senior Truth Series, I'm just going to tell you just a little bit about our journey. I work, my day job is real estate, so I sell real estate. And my niche, the people that I work with most are people like yourselves, older adults who are either downsizing into a smaller home or a different size home with a bedroom on the main level, or maybe they are moving into one of the senior communities or something like that. So lots of different, or an apartment or different things like that. And as I was going around trying to get different resources for people that I work with, I realized that it's complicated, it's confusing, and I was having a hard time knowing who to trust. And so one of the groups that I came across was a group out of Oklahoma, and they do these seminars and they have topics that they talk about, just like we're doing here with panelists. So I'm not an expert on all of our different topics, but I bring in people who are. And so I just kind of moderate that and host it, and it's been amazing. I have learned so many different things. We started last year, so this is our 16th seminar. They're all free. And the way that we can make that free is because we have education partners this year with us that are people that I trust and that I want to pass on to you and let you know that these are trusted people who are not just here to give you a sales pitch. You're not going to get a free meal at the Hereford House. Really good coffee, but no Hereford House. And but they are here because they care about you, and I trust them. So check out their services afterwards. They have their tables over here. A couple of them are up here as panelists today. So I want to thank, I'll probably cry, it's been a rough month so we talked about all these different things going on. Woo, okay, it'll pass, promise. Okay. So we talk about all these different issues, and they don't always affect me. I mean, they affect people that I work with, but this has been one of those months where, whoosh, like all kinds of things are happening. So Jake's mom's been in the hospital for 15 days. Without a few days, she's back in. She's gonna need some home health care. My grandmother's on hospice, and so just kind of all of that that's going through. You guys know I talk about my grandmother a lot. Now she's almost 101. She's been without food and water for 12 days, and she's just still holding on. So I'm not sure what's going on, but anyway, so her birthday's May 6th, and she would be 101. I hope she doesn't last. That's a long time to be without food and water. But anyway, I want to say thank you also to all of you who come and join us for these seminars, because if you guys weren't here, I wouldn't do these. I would have given up a long time ago, but I love seeing all of you, and I love you guys being here. And so it's helped me to learn different things that can be helpful as Jake's mom's going through some stuff, as my grandmother's going through things. So anyway, I appreciate you. I'm happy you're here. And I appreciate our panelists. And we are going to get started. I'm going to let them introduce themselves. Okay, our topic today is passing it on. Smart strategies for your legacy. I can't decide if we come up with too tricky of topics sometimes, like two titles. They sound really cool, but do you know what this means? So you're going to learn a lot today, I promise you. So let's go ahead and go through introductions. And nobody has said this, you're all so kind, that I misspelled a word on your sheet. I'm sure. How many people noticed? Come on, all those English majors out there. No? Okay. So Melinda and Nathan are actually principals with a PAL, not a principal LE. So anyway, I'm a math major, so I don't know. Okay, let's go ahead with introductions. Nathan, do you want to start?
This one might work too. The wireless is louder.
Huh?
The wireless is louder.
Could be louder.
The
Oh, it will
wireless
be louder, gotcha.
Well, good morning. Good morning. There we go. My name is Nathan Haskins. I'm one of the owners of Free State Advisors. We're a wealth management and financial planning firm here in Overland Park. I grew up in western Kansas in a small town. I love helping people, and I spent the first part of my career working with companies before starting to work with more people with Free State. And Melinda and I are business partners who became the next generation of Free State in early 2020. It's been fun and adventurous since then. And I'll let Melinda do more of a comprehensive introduction, but we are part of the team that helps keep current on helping folks identify your legacy and what does that mean to you and how do you accomplish it.
My name is Melinda Parks. I'm also with Free State Advisors. Like Nathan said, I came to this as a second career after a long corporate career and a big background. I grew up in a small town in central Kansas, and like Nathan, I just like helping people and I like helping solve problems. So it's been a great run, and I look forward to many years to come at Free State. All right, Mike, how are you?
Good morning. My name is Mike Fisher, and I am an attorney at Payne & Jones Charter. Payne & Jones is actually in its 99th year, so next year we're celebrating our 100th year in Johnson County, and I'm celebrating my 18th year of doing estate planning law. So I do estate planning, and I grew up in Jefferson City, Missouri, and my first experience with estate planning was both of my parents worked, and so there was a retired gentleman and his wife down the street, and they watched me from as a kid every day before I was in kindergarten, before I was eligible for school. And then they didn't have any children of their own, so they kind of took me on as their own in that regard. So I was over there Monday through Friday when my parents were working. Whenever I turned 18, he named me as the executor of his will. And so then so I went off to college, always come back, we'd always hang out, go to lunch, go to dinner. I'd see him, regularly on my breaks. But then he passed whenever I was 22, so a senior in college, just about to go in law school. And I was in charge of administering his estate, and he was his wife had passed previously. He was a wonderful man. All he had done his entire life was live beneath his means and save. And so it was amazing because he had basically, he had $1 million in railroad stock, and then I went to the bank and signed 122 CDs at his local bank one day. So I was there for hours signing these CDs as the executor of the estate. So that was my first introduction to it, and then went off to law school, and since graduating law school, I've been doing estate planning for the last 18 years, just up the road here at Payne & Jones.
Good morning. My name is Maureen Lester. I am an attorney with Complete Estate and Probate, and I do some things similar to Mike. I would put us in the same field of law, but my niche practice is in the area of elder law. And I found or became familiar with this area of law when I was in my second year of law school, and my grandfather had just passed away before that second year of law school started. And now so we had just gone through sort of that end of life journey with him, and my grandmother was suddenly single, and we were unprepared for how much care she needed. We didn't realize how much Grandpa had been doing for her. And since his decline was swift, we didn't really have an easy entry into that. It was very quick. So once my family recognized that she couldn't live in the independent living where she was anymore, we didn't know what was appropriate next. She had a fall. She went to skilled rehab. She kind of did all of the things. And I'm not sure she got a hold of my syllabus for my elder law class, but she sure went right along with all the lessons that we were learning. And so I lived it while I learned it. And after that, I immediately knew this is what I want to do. These are the people that I want to help. So since then, I have been practicing elder law. And you wouldn't know it from looking at my face, but that's been 11 years now. And so I just enjoy helping my clients and really focusing on the long-term care and final chapter of life issues that come up, and helping you have the legal tools you need.
Right. Are you guys amazed? It's an amazing group of people here. Okay, so when we first started talking about what we were going to discuss for this panel, Melinda said, oh, we kind of, because I'm like, okay, we have an estate planner, we have attorneys, what about tax? And I didn't realize that we kind of needed they don't all do the exact same thing. You kind of need all three of them to work together. Some might have knowledge on how to do estate planning or some financial, have some financial advice for you, but they all kind of merge together. And then the tax accountant or the CPA is the third kind of part of that triangle that works together to, because none of you guys do tax, right? You do the financial advising part, you're both on the estate planning side. We didn't bring an accountant in, so apologize to those accountants, but we can talk to that if you do have any questions or let you know who might be a good one to go to. So as we're talking about these three different pillars or this triangle, we also then decided that there's kind of 4 stages where you need all 3 of these people from this triangle. And so that's what we're going to talk about today. We're going to kind of talk through these stages. There's the working stage where you're accumulating money or we might be spending more, but we're definitely maybe accumulating. Retirement stage, long-term care, and then when it's time after death when you're ready to pass on some of those assets. All of those are different stages that you kind of need all 3 of those people. So it takes a village, as it works for this as well. So what we're going to do is kind of go through what each of these people do, what the panelists do, and then how they fit into these 4 different stages. So we're going to start with Mike, and just kind of give us that overview of these stages and how that works with estate planning.
Yeah, so that's a great kind of summary and a great introduction. For basic estate planning, so my view of it is that you should have a basic estate plan at all stages of life. And then my joke to my clients is, that said, if I do my job correctly, you should not have your attorney on speed dial. If your attorney is on speed dial, you're doing something wrong. So get that estate plan done, because what you're doing there is, yes, you are talking about how your assets are going to pass and who you want them to go to, but equally importantly, you're talking about who you want to make decisions, both related to your financial assets. So who do you want to sell the home, or who do you want to divide those assets and make sure they get to the people or the charities or the churches that you want to support. But also, a financial power of attorney is a person that makes financial decisions for you. A healthcare power of attorney is an individual who can make healthcare decisions for you if you are unable to make your own. And so it's really what it does, no matter any stage of life, you're sort of disaster planning. So if something happens to me unexpected, here's the people in my life that I trust that I would want to make these decisions, to either help me make these decisions or to make these decisions for me if I am physically unable to make them. And so once that's done though, once you've named those people and once you've got those documents in place, it's possible that you don't need them for years. And so you can rest easy, having the peace of mind knowing that, okay, I've taken care of that. And so now it might be years before I ever have to utilize those documents, or it might be years before my healthcare power of attorney ever has to actually step in and talk with the doctors and make those decisions. But I've got it, and I've done it, and I can check that box and know that I am in a good place, knowing that those documents and knowing that have been done and have been completed. And so then and I'm happy to answer questions at any time, so if anybody has questions.
Tell us what some of those documents are. I mean, I think we have a general idea. I mean, I think things that come to my mind are the trust, the will, like you mentioned, the power of attorney, the healthcare power of attorney. And so just kind of maybe just a quick overview of some of those that are important, because not everybody maybe needs a full plan. So just.
Yeah, so a lot of times people will have questions about the difference between a will and a trust. Those two documents do affect, so There's lots of different types of trusts. Maureen will talk about some very nuanced ones later. But generally speaking, and trusts can do a lot of things, and they do a lot of things very well. The basic estate planning trust does almost the exact same things that a will does, except that a will goes through the court probate process. So it spends 6 months to a year and a half in court, and overseeing that process is a judge. And so it can get kind of slow and kind of time consuming, but effectively your will says, here's how I want my assets to go when I pass. It can also say, here's how I want to be buried, or here's where I want to be buried, or I want to be cremated or not cremated. You can specify burial instructions. And then if you've got young children, it can also specify who you want to be the guardians of any minor children. But the core of that document is, here's who I want things to go to when I pass. So for many individuals, it's some division between children and maybe 10% to church and 10% to charity, and then divide the rest up between the kids or grandkids or nieces and nephews and whoever else. A trust document does the exact same thing. A basic estate planning trust does the exact same thing, except it avoids that court probate process. So instead of having a judge oversee it, you basically just pick who you trust to do that. And many times it is an adult child or multiple adult children that are in that role. So, for example, their job would be, if you own your own home, their job is to meet with Julie at the property, let her in, say, what do we need to do here to get this home ready to sell? Or if you're not going to sell it, if it's going to go to a child, what does that process look like? But it's effectively to meet Julie or the real estate professionals or the whoever's going to host the estate sale, or talk to your financial advisors to say, okay, what needs to be done to gather all these assets and make sure that they go how my client or how my mom or my dad or how my aunt or my uncle want them to go. Any questions regarding a will or a trust? Yeah.
How do you set up a trust versus, like, we have a will, but we really rather have a trust? So you just word that differently? You just said this is
Yeah.
who documents the trust?
So probably your attorney, whoever helped you with your will, is probably able to do that. I'm able to do that as well. What you do though is a lot of times you'll have them at the same time. So you will so it is just a different document that has a lot of the same provisions in it. You will still have a will, but that will say, it's called a pour over will because it just pours assets over into the trust. So I'd say 99% of my clients that I talk to, I don't charge any differently between wills or trusts. It's the same amount of time on my end. And so most of them do end up going with the trust, particularly if if they own their own home or if they've got children. Only because it saves time and it saves money on the back end. It makes Julie's job getting that home, getting the real estate through probate, it makes that infinitely easier. So the will just says, I want it all to go into my trust, and then the trust says, here's how my assets should go. So if you have everything titled appropriately, you don't need that pour over will, but if you forgot something, it will still get where you want it to go.
And I don't want to take up too much of your time, but like we have already put transfer upon death on the deeds of our home, transfer upon death for our vehicles. We've gone in and said, at our financial institution and said,
Like for your banks or your IRAs or those kind of things, yeah, set up beneficiary.
So,
These are really terrific questions. So, hypothetically, not to get into any details with your own plans, hypothetically, I'm going to assume that they are your adult children. As long as the natural order of death occurs, you can get the same results. If the natural order of death does not occur, then, meaning if one of your children were to predecease you, that can cause some pretty serious complications. And what I mean by that is either you can have issues getting half of a house through probate and not the other half, or You can have, I don't know hypothetically, if your children have minor children of their own, then that creates a whole host of issues because they have to have an attorney appointed to represent those children. There's a variety of unexpected issues that can occur if the natural order of death does not occur. Julie can also speak more to this, but if you have one child and they outlive you, it can be very easy and very clean and very efficient. If you have 10 children, or hypothetically, anything more than one, the more children you have, the more personalities you're dealing with. If you have multiple children, Julie can speak to this, sometimes multiple children will have disagreements as to what a fair price for the home is, or sometimes their spouse will say, I want more money than that. And just as an example, a very specific example, but I had a client with 3 children. The client came to me after they passed, so I was representing the estate at this point, but they had 3 children in a home at the Lake of the Ozarks. There was 2 children that were happily employed with jobs, and they were content to use a lake home like it was supposed to be used, and they were going to sell it because they needed to for financial. The 3rd child didn't have a job and didn't want to, it was $1 million lake home. They just squatted in it. They refused to sign on any documents, they refused to sell it. They just said, you can't really make me sell it, and so, because they were equal 1/3 owners at that point. So having co-owners that disagree on a piece of real estate or something like that can create conflict that you would otherwise avoid. But to answer your question, at its simplest form, as long as the natural order of death occurs, you can get many of the exact same legal results using that process.
Okay, yeah, that kind of answered. And we can also write your questions down. We will have time at the end for different questions as well, kind of once we get through everything. So are you okay? Are we okay moving on? We can circle back around?
Nope,
Okay.
absolutely. So
Okay.
the will, the trust, a durable power of attorney for financial decisions, a durable power of attorney for healthcare decisions, and then end of life care documents called a declaration or a common law living will that say something to the effect of, if my doctor, a second doctor, and my healthcare power all agree that it's okay to consider the withdrawal of support, I support that discussion. And that's kind of the entire basic estate planning package that I would encourage everybody from 18 on up, absolutely.
All right, well so that's kind of how the trusts and the wills and that type of thing fits into some of those categories. There's a lot more in depth. Again, like most of our seminars, we could be here all day talking about just with an estate attorney or elder law, so financial advisor. So let's just, if you guys want to just kind of talk a little bit about how the financial advisors fit into these stages. Okay.
So as a financial advisor, we do a lot of financial planning with our clients. Financial planning can and does cross over all life stages. You can develop a financial plan as early as you want, and it's an ever-living, breathing that can be updated over time as life changes. Generally, a financial plan includes your income, your investments, your taxes, your estate plan, and your insurance. Okay, so that's sort of the overview of a financial plan.
Tell me those again.
Income,
Okay.
investments, taxes, estate plan, and insurance.
And can you tell us, as you're kind of going through this too, how you overlap maybe too with estate plan? Maybe just
Yep.
at some point.
Yep. So when we sit down to do a financial plan, we're really trying to understand from a client, what are their goals and objectives? What do they, and for us it's things like, when do you want to retire? If we're doing it pre-retirement, when do you want to retire? What do you want to do in retirement? Do you want to do extra travel? Do you want a second home? Are you going to sell everything and buy an RV? I mean, what do you want to do? Do you have other things, if you're earlier life stage, are you saving for college? Do you have a wedding expense? So we're trying to understand those overall goals and objectives and what you want from a life cycle. And we're also asking them, what do you want to do with your money at end of life, which really ties in with the estate plan. Does your money just want to be left to your kids? Do you have any charitable giving intent? If they've already developed an estate plan, that's great, because they can communicate that to us. We can set up everything so it works in conjunction with that estate plan. We would have beneficiaries on their investment accounts, or we might, if we have a trust, you might set not qualified assets up as a trust. So we would work in conjunction with that. But the financial plan itself outlines, what we're looking at is the client's income and cost of living. And then we're projecting that forward so we can understand what are your future income needs in order to live in retirement in accordance with those objectives. And then when we formulate an investment approach for our client, we're considering what those objectives are, what those income needs are, and letting that inform an investment approach. And that's why we believe that doing financial planning is so critical for our clients, because it gives us better information about how we think about their investment approach. I don't know if this is the right time to talk about it. So transfers of assets at end of life is something we have a lot of conversation with clients about. And where the client has formulated their estate plan, it's a whole lot easier. But there are things that transfer in different ways, different assets transfer in different ways. So we're going to help the client strategize and execute that. And I think I'll leave the rest of the detail, maybe we can talk about that in Q&A, but we're gonna look at that estate plan, and we're gonna help execute. So in end of life, we really logistically are helping to make sure that process is in accordance with what the estate plan helped set forth. If there were financial powers of attorney and mom or dad are no longer able, we're working with those kids, right? Because they've already established those. If they don't have those established, it's really hard for us to then work with anybody else without sort of the overcover of what the estate plan documents give us.
I'll add just a couple things. So all of that is right. I would say from a financial planning perspective, one of the advantages we have ideally is to build kind of a lifelong relationship with folks who choose to work with us. Having that foundation of estate planning documents is critical. And after that, Mike said, ideally you don't need to come back and talk to me for potentially years later. Well, the benefit that we have with that relationship and getting into those conversations of what do you want, right? What's important to you? How do your emotions work versus the math of your plan, is that we're getting together, in many cases, multiple times a year to talk about what's happening in life, right? Are the kids going to college? Are the grandkids getting married, right? What are those goals that are changing, and how does your health keep up with that? So it is a chance to build on the foundation of estate planning and help be clear and intentional about your legacy, which is a really, really important thing. And then to be able to quarterback across those life stages when the critical times are to engage other professionals, right? There are times when your CPA is really important, right? Are you starting a business? Are you in your peak earning years? Are you dealing with a complicated, business sale, something like that? As we start to transition from working stage into retirement stage, how long do I need to work? How does Social Security work? How does Medicare work? Very important insurance topics in that time, as well as kind of the investment side of things throughout, where it transitions from your pure accumulation stage, where it's easy, you buy more shares, right? To now, how do I preserve the wealth I've created so that I can accomplish the legacy and the goals that I've established for myself and my family? So across all those phases, there are times where that team of professionals get used more and more. Fortunately, we have a chance to get to understand all those things. And while Melinda and I don't prepare taxes, we don't prepare estate documents, and we're not attorneys. We know some situations that can help understand the best times to engage those folks on your team and make sure that you've got the right pieces in play for where you are in life.
Sounds great. Thank you. And I do have a question. It may not be right here, but just keep this going, but sometimes I think we wonder, when is it okay, or do I actually need a financial planner? Like, what are my asks? Do I, like, at what level is that important? Or, only people who have so much money need a financial planner, or I have to have all this stuff in order to have an estate plan, or that kind of stuff. So afterwards, let's jump over to Maureen, but then I also want to answer that just to kind of, for myself too, just to hear. So, all right.
Excellent. And is this microphone loud enough for everybody? Okay, fantastic. All right, I will Britney Spears this.
Try the other one.
Okay.
I don't know, that one's, can't hear you.
All right, let's test this one out. Maybe I'm just, okay, great. All right, fantastic. So you may have had the best laid plans with Mike. You met with him in your young married years when you had little kids, you named, siblings to be their potential guardians. You've survived and didn't need it, hooray. And then you meet with the Free State Advisor group and they walk you through your retirement stages. You have everything perfectly planned out as to how this should go. And then disaster strikes. And it's unfortunately more common than any of us would like to believe. So the statistic is that about 70% of us will need long-term care, and that's defined as over 100 days of hands-on care for at least 2 of your activities of daily living. So the sad truth is that most of us will need long-term care. And sometimes even the best laid plans get rocked by that need. Because if any of you have ever had a family member, a neighbor, or a friend that you've helped them with their long-term care, you know how hard that work is. If you've ever needed even short-term care after a surgery or something, you know how hard that work is. And you very likely also know how expensive that is. And it's no surprise to anybody, costs are not going down, especially in the care spectrum, right? Costs are going up for everything. And so unless you've really built in a very, very strong plan for how to deal with long-term care, the financials, and sometimes even the estate planning, don't support the situation that occurred. So that's where I come in. And that's where I help my clients figure out, how do we handle this disaster? And sometimes people want to come to me just to figure out, given my situation, given these other plans that I've created in the past, am I well set up for what's coming next? And I love when I get to send my clients out the door and say, your plan is great. You have enough money to support you and your spouse for a very long time. Or the long-term care insurance plan that you bought covers this situation, and you're going to be in a very good position for at least X amount of years. I love those meetings where I do my analysis, let them know for sure that their plan is going to work. But I don't get to give that advice all the time, as you can imagine. So in my disaster planning, oftentimes I am assessing the situation at hand and figuring out who all is involved, who are all of the players, who are my people that need care, and how realistic is the care situation that's occurring now. So often, there is one spouse who is ill or physically unable and losing strength quickly, and then we have another spouse who's doing their darndest trying to take care of them. And I take time to make sure I'm understanding both of those spouses' goals and situations, because I want to make sure it's realistic for that caregiver spouse to keep doing what they're doing. I'm asking about their age, their health, their strength, and also their mental health, because being a 24/7 caregiver is exhausting. And frankly, nobody can do it, but there are a heck of a lot of people who try and then they begin to fail. So we talk about, what would it look like if that caregiver spouse suddenly fails because they have a health issue? Now we are really in crisis mode. So we work on putting practical things in place, right? If there are people who are helping for free, those neighbors, friends, adult children, even adult grandchildren, spouses, we put those just absolute crisis plans in place. Who's jumping in to stay the night with dad if mom has to go in the hospital? Or getting your name and your information in with an in-home care company so that if disaster strikes in the middle of the night, you call the in-home care company, they already have your info on file, and then they can be there the next morning. So just thinking through those practical pieces. Then we take it to the next level and we look at, do we have the legal tools in place that we need to do that? And so I'll be looking at the documents that Mike drafted, and if they're you've been in practice 18 years, if they're 18-year-old documents, we might be looking at updating those because laws have changed, situations have changed, and we're also looking at a new chapter. We may need things added to the power of attorney that was appropriate 20 years ago, and now we need new provisions that are appropriate for today's circumstances, where we might be looking at blowing up your financial plan. Sorry guys, sometimes that happens, but sometimes we have to blow up that plan in order to achieve these new goals that have just arisen. So looking at updating those powers of attorney and making sure they're appropriate for that current situation. We're also going to be looking at how are we going to finance this long-term care journey. So we do our best to predict what that can look like. And one of the primary things that I do with my clients is education, because it's not my role to choose what is the best long-term care journey for you and your loved ones. That is your choice to make, and I want you to know all of your choices going forward, what those options are and what they realistically mean. Sometimes we bring in a geriatric care specialist to make an assessment to give me and the family a better idea of what that health prognosis looks like. We have one here in the room, Liz with AgeWise, will come in and assess your loved one and say, you know, realistically, I think this is what we're looking at from a care perspective. This is what they need. This would be the level of care that's appropriate for them. So I educate you on those levels of care. What does in-home care actually mean? How much does it cost? And what benefits are available? How do you pay for in-home care? What does assisted living mean? What does memory care mean? That's a marketing term, by the way, not a legal term for care. And then what is skilled nursing? What is that like? Is it as scary as I think it is? Or can it be a good experience, and how do I ensure that happens? We talk through these different levels of care, how much they cost, and then where benefits kick in. And that becomes key to wrapping all of this together. When we look at the money that's available to pay for that plan, we can run a projection that says we're gonna run out of money in 3 years. And that doesn't work when you have a spouse who's still living at home or still living in independent living at the cost of $4,000 or $5,000 a month, right? And they're happy and thriving in that environment, but now we're paying for 2 care facilities. So I'm just the advisor about what this looks like, realistically what it costs, and when those benefits kick in. Then the most difficult part, the most involved that I ever get is how do we tap into those benefits? Primarily Medicare and Medicaid. What do they cover? When do they cover? And how do we make sure that we're eligible for them? So I walk families through, and that's what most of my outline talks about. The type of planning that I do depends on how quickly we're going to need to tap into those benefits. The crisis mode is when we need to tap into those benefits within the next couple of years. It might not be tomorrow, it might not be immediately, but it might be within 2 or 3 years. Well, if you can finance that care for 2 or 3 years, or you can keep somebody at home for 2 or 3 years at a lower level of cost, great. And then when we need to move up, we have a plan for how we do that, and we can tap into benefits almost immediately to start paying for assisted living, to start paying for skilled nursing care. So then we are going to be doing things with those assets. We might be, again, private paying for a time, and then you know that when your loved one goes into assisted living, now it's time to activate the plan. So we might be moving money between accounts. We might be slowly liquidating an IRA over a couple of years to draw out the tax burden over a couple of taxable years. So you can see how closely I am working with the whole team to figure out what's going to be a good way to handle this. Now that's when we're in a crisis mode. And sometimes people do need me to literally get them benefits the very next month. And I can sometimes do that. Usually it's within 2 or 3 months though that I can get somebody onto benefits. But the planning that I really like doing is the proactive planning. So if we know that we have more than 5 years, that is our magic number. If you've ever heard the term 5-year look back, that's what that's referring to. If we know that we have more than 5 years before we're going to need long-term care, or before our money runs out to pay for long-term care, then we can do some proactive planning. We can proactively shield benefits by using a specific kind of trust. And that is my favorite planning because I get to educate clients on the kind of trust and the pros and cons, because for a lot of families, using that kind of protective trust, while yes, it would do the job and protect the assets, it's not a good idea because of the people that are involved or because of the assets that are involved. I was just speaking with a client who has like the perfect situation. His wife has memory care issues, and she's very healthy physically, so we know she's going to need care for a long time. But there's a mortgage on the house, so putting it into this shielded trust is almost impossible. And there are there's life insurance policies, but there's a loan on a life insurance policy, and so we can't put that in. So there's all of these just things where, while it would be a great tool for this client, there are certain aspects of the actual practical nature of that plan that just doesn't work. So that kind of planning, looking at educating clients on how to protect the assets, who are the people involved, and really assessing and talking with my clients about really the family dynamics, because you almost always have to involve family members in that shielded, protected kind of plan. I should mention, we use an irrevocable trust in order to shield the assets. It's not a legal term, but the traditional or typical term you will hear when referring to those trusts is either an asset protection trust or a Medicaid asset protection trust, is sometimes what they're referred to. So I shorten that to a MAPT, Medicaid Asset Protection Trust, is what I call them in my office. So we use one of those trusts, but I get to really put all those puzzle pieces together, and I'm the kind of gal who loves a good puzzle. So I enjoy.
That's my visual, actually. I wish I had a puzzle piece of it, because I think you're all doing that in some aspect. It's like this living, breathing thing that evolves as we move through these stages, and sometimes you guys are more important, sometimes one of you two are more important, but it's always putting all those pieces together. And it does seem really important to be able to talk to all those different, the estate planners, the financial planners, the families. We could have probably added a few more legs to our triangle, but just to incorporate everyone together. I wanted to mention, sorry, I didn't let you wrap
No,
up.
that's
I
all.
interrupted you. Okay. Some of the information we have in your handout is we decided to just kind of give you questions. So if you feel like you need to talk to a financial planner, here are some questions that you could ask, or that you might want to have some information for, or if you're going to meet with an estate planner or Maureen, or do some type of, that was more elder law, kind of more, a little bit more crisis, or those types of questions. So those are in there. If you're wondering what the 3-hole punch is, it's because we do have binders. So if you like to keep your stuff in binders, we can do that. You're my poster child. I like you. She has my binder. Okay, I'd like to open it up, or see if there's anything else you guys have. I'd like to open it up for questions. And again, I know there's going to be some specific questions. They will stick around afterwards, and you can ask them more specific questions as well. Anything you want to start with? Anybody have anything? Sandy?
Yeah, on elder law, what about Alzheimer's? How do you handle a patient or a client that comes in that has Alzheimer's?
That's such a good question. The question is, how do I handle working with a client who has Alzheimer's? And this is something that I learned way back in law school, and is consistently reviewed when I go to elder law specific education, because it is so difficult. And I'm not a medical trained person whatsoever. So interestingly, lawyers have these rules of ethics, and there's one that specifically talks about how do you help a client who has diminished capacity. So if somebody has slightly diminished capacity, then I can still work with them, and I am obligated to, by my ethical code, to work with them to the greatest extent possible. So whenever I'm meeting with clientele, I'm determining, are they completely incapacitated and I cannot work with them as a client, or do they have diminished capacity? And when they have diminished capacity, then how do I change the way that I have conversations with them? How do I change the way that I work with them? And how do I put them and myself and their family members in the best position possible to make sure that they understand the advice that's being given to them, that they're making informed choices, and that I know that's happening. So I will adjust my style and also do a, they don't know I'm doing an assessment, but I'm doing an assessment on their ability to process and understand. It's a
Do you
great
feel
comment.
that many of them already have some type of power of attorney in place when they come to you, or is that one of the things, and really, it could be at any level, it doesn't have to be kind of in a...
I would say a lot of clients do have a power of attorney, but so often we are doing things that weren't taken into account back when that plan was made. So we may need to change or update, or even if those things were taken into account, it was long enough ago, or they had a different attorney. Now it's my job duty to make sure that circumstances haven't changed since they created that plan, and that I can still rely on the choices that were made 10, 15 years ago, that is still the most trusted person to make those decisions. So I'm always doing my best to involve that client as much as I possibly can, to the extent that is practical.
Do you guys want to add to that as far as,
I mean, we end up in that situation periodically, right, where you have a diminished capacity client, and so sometimes it's, we start working with the next generation with kids if the adult wants those kids to be involved. And then if capacity diminishes too much, then we're relying on the estate planning documents of who has power of attorney, how do we work that with us as well as the custodian. So it's an overlap for us as well.
does that kind of answer your question, Sam? Anyone else have a question? Surely you do. No?
Yeah, I guess this is probably for Mike. And going back to this lady over here about POD and TOD. So, if you have that clearly designated on all of your assets, so I think you were saying that the potential landmine is if you have 4 children and you designate one of them as on your home, let's see, as the POD or TOD. So I think you're saying the potential landmine is, this is what I have designated. We have 4 children, and all the other 3 know exactly that this is the guy that we have said is we're gonna transfer the house to him, okay? Now, granted, there are those potential landmines, as you indicated, because somebody may have a different opinion on the value of the home and those kinds of things. From a legal perspective, if we have said, this is the guy that we're gonna transfer the house to, it doesn't matter what anybody else thinks. Now, the potential landmine is everybody's gonna get all pissed off and it's gonna disrupt the whole family dynamic and all that kind of stuff. But if this is the guy that we have said, he's gonna own the home, he's gonna sell it with Julie, and then he's gonna distribute the funds because we've designated all that kind of stuff. From a legal perspective, can anybody stop that process? Any of the other 3 stop that process?
So you hit on a couple really good topics there. If you designate one of 4 children on in Kansas, it's called a transfer on death deed.
Right.
In Missouri, it's a beneficiary deed.
Right.
They technically become the legal owner of that home, and they don't have to divide the proceeds.
Right.
So that becomes theirs. So if the idea is that they're going to sell it and the proceeds are going to be split legally, they're not going to, your other 3 children would not be able to there's a lot of circumstances that come up, but reality is that they would have a difficult time forcing that child to divide the proceeds of that home. And if the other three decided they're gonna hire an attorney, much of that effort would be spent in attorney's fees just to get that child to divide the proceeds of the home. Because legally, with transfer on death and pay on death, whoever you've named becomes the owner of that asset. So real estate is the most complicated, in many estates, real estate is the most complicated thing to deal with because of challenges like that. So that one child could decide to keep the home, not sell it, and there's nothing, well, it would be very difficult for the other three to do anything about that. If the idea is that you do want that asset to go just to that child, then using the transfer on death deed or the beneficiary deed may be successful in that regard, but I would still encourage somebody to make that wish known also elsewhere. Yeah, simply so it is clear that we are giving that person the home, and then you're doing whatever else you're doing with your other assets or not. But we did this intentionally. We want to avoid a dispute between our children. So that you've nailed a really good point there. The other point that I was making is, if you've got 4 children and they're all married, that's 8 people that potentially have to sign off on a deed. It's just time consuming. It's difficult for Julie to deal with. And
but it's probably easier than expecting someone to divide it up later. Sometimes can be more difficult. So it's now with technology. Yes, there's a lot of lines on the contract, but it's a one-time thing to set up. They just click on it. It's very doable as far as that. And then many times it will go into the trust, and then the trust takes care of it from there. But there's a lot of different ways to do it. But it's a lot easier than it used to be logistically for the signing.
But just to clarify, if we have made it known that we're doing a transfer on death deed to one kid, and the other 3 are aware of it, okay? And the idea, and we've made it known, and however we're gonna do that, we've made it known that once Julie sells the house, then whatever the process would be, those distributions would be divided equally 4 ways. No, so just to verify what you said, if the other 3, even though they know that kid number 1 is gonna be TOD, and when Julie sells the house, everybody knows that the process is gonna be distributed equally, 25% to each one. The other 3 could challenge that by hiring an attorney and challenging that process. But, and I'm just seeking clarification on what you said, they're gonna spend a hell of a lot of money doing that. Of their own money, because there's been nothing distributed from the real estate yet, right? I mean, they could challenge it, but they better have some pockets to do that.
Correct.
Okay.
More likely though, and just to be very clear, the most likely scenario in that regard is the person that you've named as the TOD, they change their mind and they're not going to divide those proceeds. So that house legally becomes theirs. So you are putting a heck of a lot of trust in that person, because not just trust, but the house legally becomes theirs. They do not have to divide those proceeds. They do not have to sell that house. They are now the owner of it and can do whatever they want with it. And so that trumps what you put in your will or what you put in your trust, because that asset never went through the will and that asset never went through the trust. It went directly to that person. So the most likely problem there is that child number 1, let's call it me, I decide, oh, you know what? Instead of dividing this 4 ways, I'm gonna divide this 1 way, and that 1 way is gonna be me. That's whenever those other 3 are gonna spend a lot of money just to get what they should have gotten had you done it differently.
So at some point, you gotta have faith and trust.
Well,
I think
Right?
some of it is a little bit, but you just have to know the legal ramifications, right? You have to understand what you're doing, and it sounds like you kind of do. You know what you know, yes, maybe you're trusting number one child, Mike, here to divvy it up, but I mean, I think,
Yeah, to clarify that real quickly, I would say, no, you absolutely could have it done a better way to avoid that.
Okay.
Meaning, instead of having it legally become the asset of one and then trusting them to divide it up for, you could legally have it become that this is going to be sold and this is how it's going to get divided up, because that's what our documents say. The documents currently in your hypothetical do not say, the words may be there, but it's not in a legally enforceable manner, if that makes sense.
Yeah. One of the things that we do, we look at a lot is strategizing with clients about asset transfer at the end of life. And broadly, real estate is an asset category. A lot of people still have a home at end of life. There are non-qualified assets, so that's an investment account or money or bank account that it didn't come from a retirement plan, right? So that passes in one way. And then there are qualified retirement assets. Those can be pre-tax, then much of yours will still probably be pre-tax. Some people in the next generation especially will have Roth, which is after-tax dollars. Each of those buckets transfer differently to your heirs, and it's important to be strategic about that. Talked extensively about the real estate piece. We're talking a lot with clients about the pre-tax income, so the qualified retirement income, qualified retirement account you have, that when you take money out of, you pay taxes on today. When that money passes to a spouse, it becomes your spouse's IRA and is taxed to your spouse the exact same way it was to you. So no real change. But when that money passes to your heirs, to your children per se, that money now becomes taxable to your children. And your children have only 10 years to take all of that money out. That law changed at the end of 2020 or around 2020. So that's different than what it used to be. So if you have a large qualified retirement plan account, an IRA, and you die, and that's going to go to your 2 kids, you have to understand that your 2 kids are going to pay tax on that at least in the next 10 years. And that can happen that you are leaving that money to your kids in their peak earning years in the highest tax bracket. Now, some of our clients will say, I don't care, I'm leaving the money, they can use that money to pay taxes, and that's fine. We're never here to tell you the answer. We're here to guide you to think through what's important to you in that answer. For some, so let me back up, a qualified account, or a non-qualified account, so account that you didn't accumulate through a retirement plan, it's a brokerage account, a cash account, it's called a brokerage account. You own some stocks and bonds. When you die, and that, if it wasn't already in a trust, it goes to your heirs, it's transferred on death to a couple of your kids. And let's say you've had that for a long time, and there's some big capital gains on that. Well, when your kids inherit that, they get a step up in basis. So at the date of your death, that account has 0 capital gain on it, right? So no tax implications to your kids at date of death in that transfer. So it's just important to understand how different types of assets transfer. Real estate's the same way. It's going to transfer to them, and their value, their basis is going to be value at date of death. So what does that mean, and why does that matter? One of the things that we're finding with people, if you want to give charitably in your estate, it's important to you when you die for a piece of your estate to go to your church, your synagogue, the American Heart Association, the Alzheimer's, whatever that is that's important to you. You want to do that out of your qualified retirement money because there's no tax to those nonprofit entities. So I had a client who had money in non-qualified and had money in an IRA, and they designated the non-qualified money that had no tax implication to her heir to go to the charity, and left the IRA money to the daughter who now is paying taxes on it, taking it out. So we're trying to really help people understand the new tax law and help them be strategic. Again, we're not telling our clients you should give charitably in death, we're just helping them to think through what the implications are, and then get everything assigned and set up the way they want it to pass most efficiently in minimizing taxes. Most people want to minimize taxes, not all of our clients, but a lot do. So that's something I wanted to pass on.
I think that's good to know. And I think this is another way where you're working, like you know some of the tax rules and some of the tax laws, and as a financial advisor, they can say, here's one of the new laws, or here's what's changed, but she's not gonna do your taxes, or she's not gonna be the one that calculates all of it. So you guys are, again, it all works together.
And a lot of people will worry about estate taxes. It's I want my assets to pass to my kids, but I don't want to pay any estate taxes. And the reality is tax law today allows for a pretty large estate to be excluded from estate taxes. It's like 14 million.
Like 15
Or
million.
it's a lot per person, so if you're a married couple, it's even more. Most people won't hit that. And even if the tax law would change in the future back to a lower amount, it's still $4 or $5 million. Most people aren't going to be in a situation. If you are in that situation, you should be having a conversation with your estate plan, with your tax CPA, with your financial advisor to try to minimize taxes in that transfer.
Yeah.
Am I understanding correctly, like if my house is set up so that it's going to go to my daughter, then she does not have to pay taxes on that? Okay, but if she is, like from my estate plan, I have an IRA, when that transfers to her, which it's set up to do, then she will have to pay tax on that.
She'll have to take it out. So the question is her house, would her house have a tax implication to her daughter? Probably not. She's gonna inherit it at the valuation at the date of death, and if she sells it right away, there's no capital gain, and there's different capital gain rules on houses anyway. But when your IRA transfers to your daughter, she has to take that money out within 10 years, and nobody's paid tax on that money. So somebody's paying tax on that money. So she's gonna pay tax on it as she takes it out over 10 years. It used to be that your child could take that money out over their remaining life. So if you were in your 30s or 40s or even 50s, it could stretch, it's called a stretch IRA. It would be a really small dollar amount that they had to take out every year. So it was less penalizing in a shorter window of time. I could stretch that out while I'm still working and take it after I retire. My tax bracket is lower instead of having to take it on top of my income when my tax bracket is higher. So it's just important to understand how those rules changed and how they impact your heirs. And did that answer your question?
She has to take it out in 10 years?
She has to take it out and pay tax on it. It's taxable to her when she takes it out, just like it's taxable to you today when you take withdrawals out of it.
Yeah, and here's where I get to throw a wrench in things. So, it's the same, thank you, I don't know. So it's the same body of federal law that protects older adults and individuals with special needs or individuals with disabilities. So if there's anybody in your family who has a disability, then I get to use those old rules of the stretch IRA. So that's literally how niche my area of law is that I know how to work with these folks when there's that really narrow exception, and we can have some really incredible financial outcomes with just a little bit of careful planning.
Fantastic. Okay. Any one last question? Let's just go through and just maybe quickly just kind of say one thing, if there's one more thing you want to mention or one thing that they kind of could remember at their leave today, remember this about financial planning.
Sure. There's so much I could add on to every one of these questions. It's hard not to. I think the important part is to be intentional and have a conversation with somebody who will listen and kind of cares about your outcome. Because there's kind of the default path. Let's say I read it in Money Magazine, or I searched and Google spit back an AI result. There's some truth in that. There's a lot of nuance to all of this. So I like to think of collaborating on a financial plan as navigating a game where the rule book is like this thick. And it is really important for you to get the outcome that you desire, to be intentional about how you play that game. Obviously, it's a very important game because it affects you during your life, it affects your children and your grandchildren and your charities and all sorts of things. But to be intentional, build a plan and stay on top of it because it's a living, breathing thing, just like your life is and how things change over time.
And all people, I mean, at any level, there's, you can have a financial plan at any level. Yeah, you don't have to have 15 million that you're gonna share or even $1 million or, you know, it's just a plan, and they're willing to talk through that plan with you.
I have plans for lower 20 grandkids of my clients, and it may not take the same level of exploration as someone who's 62 and thinking about early retirement, but it's certainly important to have a piece, a vision in mind of what is my number, what do I need to save, how should I invest to get there, those sorts of things, in addition to building those foundational estate planning documents, to thinking about life insurance when it's cheap to buy it, all sorts of things.
I think my one takeaway is to make sure that you have partners, as Julie outlined, that are people that you are comfortable communicating with. Because we get into intimate conversations with our clients, right? It's a very private matter when you're talking about finances. So you need to have somebody that you're comfortable with, someone that you can trust, and who's willing to work on your team. I loved how Julie outlined this from the beginning. We're part of that team. We don't have CPAs and estate planners at our firm, but we gladly will partner in and work with others to sort of be part of that virtual team for our clients.
From my perspective, you can probably guess what mine is going to be, but if you do not have an estate plan, or if you haven't looked at it in a number of years, get your basic estate plan done so you've got that peace of mind. And if you haven't looked at it for a couple of years, it might make sense to reevaluate. The laws have changed. It might end if and more importantly, your life circumstances have changed. So pull it out, make sure it's still what you want. Feel free to talk to somebody that's able to assist in that regard.
I think my takeaway is lay your careful plans, set that path, and I really, really hope you make it with no stumbles along the way. Don't get distracted by the what ifs that are off on the side of the path, right? Don't prevent yourself from making that smooth, clear path ahead of you. And know that if one of those what ifs does come to be and a crisis occurs and now all of a sudden there's a big boulder in front of you and on your path, there are specialists like myself who will help you understand how to get around that boulder. Maybe you go to the left and do it this way. Maybe you go to the right and do it this way. But somebody who can walk you through what those options are and what those outcomes look like.
Thank you. So one of the things that we like to do at the end of the seminar is we have the education partners, and each month I have one of the education partners gives a gift basket. So we have all the names here. Tracy wrote all these in. Tracy's been here with me since the beginning. You can come on up, Lee, and I'll let you talk for just a minute. Bring your basket. Awesome.
Well,
Okay.
I've got it.
Okay, good. And say a little prayer for Tracy and her family. They just had a little emergency, so anyway, keep her in your thoughts. So I'm going to have Lee talk just for a quick minute about what he does. He and I can work together, and some of you have equity in your home that maybe you can use in other different ways. So
That's probably not the setup he was looking for.
That's okay. My name's Lee Smith. I work for a company called Fairway. Well, actually, as of next month, we're having a new DBA called Fairway Home Mortgage. We're one of the largest companies you never heard of. We have over 5,000 employees all over the country, and we do boots on the ground. We don't advertise on TV or anything like you see with the big ones. We're just, in everybody's community, neighbors. And it's funny because I work with pretty much everybody up here. I've worked with to some capacity or had conversations about, but my biggest thing is, I specialize in the best way to use home equity as part of the retirement plan. I always often joke, the cell phone you have in front of you has more technology than they used in the 60s to get to the moon. Think about that. There's more technology in an iPhone than in the shuttle that got them to the moon. Unless you don't believe in that, then we can always talk conspiracy. But my point on that is that everything changes and evolves over time. And I find it interesting that we are still treating the home the same way as maybe our grandparents or parents, grandparents, or even great-grandparents did. Everybody's industries have changed over the years, so has the best way to use that home equity. There are safe, secure, and guaranteed ways you can access that money. In most cases, tax-free, that doesn't add any risk into your overall portfolio. or your retirement plan. So I love having those conversations, digging deep. I have a gift basket back there, and I think I'm gonna have the most expensive one because I do have a dozen of farm eggs. Which I don't know, I mean, I live over, I call it the redneck Johnson County, so it's Johnson County, Missouri. So we get like a dozen and a half to 2 dozen eggs a day, you know, from the chickens we've got. So they are wiped off. We don't wash them, but they're also going to be good. You know, the stuff you get from the store is like a couple months old. These are probably less than a week. And we do have every now and then we find double yolks in some of the eggs. So, you know, I don't know. My wife just gets excited about it, but, you know, I don't really care. So.
Okay, well, you can close your eyes.
Oh.
Well, this one has a coffee stain, that's special.
Well.
Okay. There you go.
Oh,
Try your pinky.
there we go.
Okay. Here we go.
Jackie?
Oh, but I'm not gonna take the exciting.
Oh, because you won last week.
She's a better person than I am.
Oh, yeah, I guess we can take it.
Joyce?
Thanks, Reed. Honestly, we couldn't have these seminars without the education partners. So, Free State Bank is also an education partner, and a couple of people over there. I want to mention that there is a survey or a feedback form. I know if you've been here before and I have your address and all of your particulars, you just put your name there. But it is important, if you mark that you're going to come to one of the seminars, I will put it in. You don't have to go in and register. I will do that. So just give me your full name because we already have some duplicates. And any information you can put on here is great. I do appreciate it, and I do read all of these. I would love your address because sometimes I just send you a little thank you notes and things. So anyway, anybody have any questions? I know they're going to stick around. Next month, let's see here. Okay, our next seminar is on May 21st. Senior helpers will be here with some other people, and it's support at home. How to navigate when you're some of those options for getting support while you're at home. You want to stay in your home, you want to stay in your apartment, and how can we make that happen for you? So, all right, I appreciate it. Thanks again, and we'll see you in May. This is a little bit earlier because I'm out of town the last week of May, so this is kind of like the third Wednesday, so it's going to come up fast. So put it on your calendar. All right. Have a great month.